All right, so today we're diving into something that I think a lot of people in California especially are going to find pretty relevant.
Yeah.
Attorney for Eviction, California.
Big topic for sure.
It's huge. Yeah, and I think especially in California where it's so expensive to live, it can be really scary to think about the prospect of getting evicted.
Absolutely.
So what we're going to do today is we're going to try to give everybody listening a little bit more clarity on, what their rights are and how this whole process even works, because I think a lot of people don't even know where to begin when it comes to this stuff.
Exactly. And so many people feel so powerless. But, California law actually provides significant protections for tenants. And that's what we're going to talk about today. And the first thing that's important to know is that in California, it's not as simple as your landlord just saying, hey, get out. It's a formal legal procedure.
Right.
It's actually called unlawful detainer.
Okay. Unlawful detainer. So that sounds a little intimidating.
Yeah.
Gotta say.
Yeah.
So if somebody's landlord wants them out, what are the actual steps? Like, how does that actually play out?
So it always starts with a written notice from the landlord.
Okay.
And this notice has to clearly state why they're trying to evict you.
Yeah.
If you don't respond to that notice, like if it's about unpaid rent and you don't pay it, or if it's a lease violation and you don't fix it, the landlord will then file a lawsuit with the court. And this lawsuit is called a summons and complaint.
Okay, so a summons and complaint. So now we're officially in the legal system.
Exactly.
So what happens after that paperwork is filed?
Well, this is a critical step. Once the lawsuit is filed, you, as the tenant, have to be formally served with those documents, the summons and complaint. And there are very specific rules about how this must be done to make sure you have been legally notified.
Got it.
And generally, it needs to be delivered to you personally, which means the documents have to be handed directly to you or someone of suitable age at your residence. So just getting a letter in the mail or even a notice taped to your door is often not legally good enough.
Interesting.
And in fact, if you weren't served properly, this can actually be a strong legal defense.
Really? So if somebody's listening and they think, that service didn't seem quite right, they should look into that.
Absolutely. Yeah. And once you're properly served, you then have a very short window of time to respond to the court. Usually it's just 5 calendar days.
5 days.
That's not a lot of time. So you need to act quickly. And if you miss that deadline to file a response, you could lose your case automatically, even if you have a good reason why you shouldn't be evicted.
Wow, 5 days. That's stressful.
Very stressful.
So what kind of challenges do people run into with that? Like, are there strategies for handling that?
Yeah, I mean, a lot of people are dealing with the problems that led to the eviction in the first place, right? So they might be having financial issues or health problems or job loss.
Right.
And it's hard to find legal help quickly. So the key is to seek help immediately. There are a lot of legal aid organizations and tenant rights groups out there that can offer guidance.
Okay, so speed is really of the essence here.
Definitely.
So let's say a tenant does manage to file a response within that 5-day window. What's next?
Okay, so if you file a response, the case will then move towards a trial.
Okay.
And that's where you and your landlord can present your arguments and evidence to a judge.
Got it.
So this is your chance to tell your side of the story and raise any legal defenses you have.
So you get your day in court, hopefully.
Right.
So what if the judge rules in favor of the landlord, though? What happens then?
Well, if the landlord wins, the court will issue a judgment in their favor, which means they legally have the right to get their property back.
Okay.
Along with this judgment, the court will issue a writ of possession.
Okay.
And that's the final order. It tells the sheriff's department to post a notice on the property, giving you one last chance to move out voluntarily.
Okay, and then what if you still don't move out?
If you don't leave after that final notice, then the sheriff has the right to remove you and your belongings from the property.
Okay, so it's a serious business.
Yeah, it's definitely a structured legal process with steps that need to be followed.
Right, so we've talked about the how of the process, but let's talk about the why. Like, what are the legal reasons a landlord can actually start this whole eviction thing against a tenant?
Sure, so the most common one, and I think this is what people think of first, is not paying rent. If you fall behind even by a day, in some cases, that can be grounds for eviction.
Wow.
But there are other reasons, too, that have to do with your behavior or the property itself.
Okay, like what?
Well, another common one is violating your lease agreement.
Oh, right.
And that can mean a lot of things.
Yeah, give us some examples.
Sure. So You could have a pet when your lease says no pets.
Right.
Or someone's living there who's not on the lease. You could be making a lot of noise that bothers the neighbors.
Right.
Running a business out of your apartment. Making unauthorized changes to the property. Things like that.
Got it. So it's not just about who's living there or pets.
Right.
What else can get you into trouble?
Well, anything illegal on the property is a serious problem.
Right.
Damaging the property beyond normal wear and tear.
Okay.
Being a nuisance to the other tenants.
Got it.
Also, if your lease ends and you don't leave or sign a new one, that's called holding over. And that can lead to eviction. And then in some cases, the landlord might want to take back the property for their own use, which is called good faith intent to repossess.
Oh, right. I've heard of that. So, like, what are some concrete examples of that?
Well, maybe they have plans for major renovations.
Yeah.
Like, so big they need the unit empty or they're going to demolish the building.
Right.
Or a common one is a family member wants to move in, like a parent or child.
Okay.
But it has to be a genuine intent.
Right.
Not just a way to get you out.
Okay, so it's a lot more than just not paying rent.
Exactly.
Now, you mentioned these notices that the landlord has to give.
Yeah.
And it sounds like the type of notice you get really matters.
It does, yeah. The law is very specific about the type of notice based on why they're evicting you, and the landlord has to get it right.
Okay, so let's break it down. What are the different notices a tenant might get?
Okay, so for not paying rent, the standard notice is a 3-day notice to pay rent or quit.
Okay.
So you have 3 days to either pay the overdue rent in full or move out. And this notice has to include some very specific info. It has to state the exact amount of rent you owe.
Okay.
The name, phone number, and address of who to pay.
Yeah.
And the exact dates the rent is for. They got to get this exactly right.
Really?
Even a small mistake in the amount owed can invalidate the whole thing.
Wow. Okay, so if you get one of those notices, you should definitely check those numbers very carefully.
Absolutely, compared to your records.
Okay, so that's for unpaid rent. What about if the landlord's saying you violated the lease?
So if it's a lease violation like that unauthorized pet we talked about, you'll usually get a 3-day notice to cure or quit, which means you have 3 days to fix the problem.
Okay.
Like remove the pet or move out, and the notice has to clearly say what the violation is and how to fix it. But for some serious violations, they can give you a 3-day unconditional quit notice.
Oh, wow.
And that means there's no chance to fix it. You just have to leave in 3 days. And this is for things like major damage or illegal activity.
Okay, so that's serious business.
Yeah, very serious.
So those are all 3-day notices. Are there any times when you get a longer notice?
Yeah, for sure. For month-to-month agreements where there's no fixed lease,
Right.
the landlord usually has to give a longer notice if they don't have a specific reason related to your actions, like if they just want to end the agreement.
Okay.
So if you've lived there less than a year, they need to give you a 30-day notice to quit. And if you've been there a year or more, it's usually a 60-day notice.
Got it. Okay, so it's really important for people to read these notices very carefully, right?
It is absolutely. And understand what they mean, because you might have more time than you think.
Right. And what if the landlord makes a mistake on the notice, like the dates are wrong or something like that? Can you use that as a defense?
Yes, definitely. Improper notice is a big defense for tenants.
Okay.
So if they use the wrong type of notice or leave out important info like the exact rent amount or a clear description of what you did wrong, or if they didn't serve you the notice properly, then the whole case could be dismissed by the court.
Wow.
The law is really strict about those notices because they're supposed to give you a fair chance to understand and respond.
Right. Okay, so improper notice, that's a big one.
Yep.
What are some other important legal defenses that tenants in California should know about?
Well, another big one is the landlord's duty to maintain the property in a safe and livable condition.
Okay, right.
California law says landlords have to make sure your rental meets basic health and safety standards.
Right.
So that means no serious hazards like mold or pests. Working utilities like plumbing and heating.
Okay.
And the structure of the building has to be sound.
Got it.
Now, if the landlord doesn't fix major problems,
Like what kind of problems?
like no hot water or major roof leaks or dangerous electrical stuff,
Right.
and you've notified them in writing and given them a reasonable time to make the repairs,
Right.
then you can actually withhold rent.
Okay.
And that can be a legal defense if they try to evict you for non-payment.
Okay.
But you have to have proof that you notified them in writing and gave them time to fix it.
So it's not just like, oh, I'm not paying rent because something's broken.
Right, exactly. You have to follow the process.
Okay, so what about repair and deduct? I've heard about that.
Yeah, that's another option.
But how does that work?
So if your landlord doesn't make repairs after you've given them proper notice, you can pay for the repairs yourself and deduct the cost from your rent. But there are some rules.
What are the rules?
First, the problem has to make the place uninhabitable, like seriously unsafe or unhealthy. Not just a minor inconvenience. You can't deduct more than 1 month's rent. You can't use it if you cause the damage. And you can only do it twice a year.
So it's a tool, but you have to use it carefully.
Yeah, exactly.
What other defenses should tenants know about?
Well, if you get that 3-day notice to cure or quit, and you actually fix the problem in those 3 days, then they can't evict you. You've done what they asked.
Good.
And it's also illegal for a landlord to evict you based on discrimination.
Of course.
And that includes your race, religion, gender, sexual orientation, disability, family status, all of that. So if you think the eviction is because of discrimination, that's a strong defense.
Absolutely. And what about if the landlord is retaliating against a tenant for, like, asking for repairs or reporting problems?
Yeah, that's illegal too. It's called retaliatory eviction.
Okay.
So if you recently asked for repairs or reported something to the housing authority, and then they try to evict you, that could be retaliation. And there are specific timelines that make it more likely to be retaliation, so you need to act fast and document everything.
Okay, good to know. So we covered a lot of legal stuff here.
Yeah.
But what about if the landlord just tries to kick you out without going through the courts?
Yeah, that's a great point. In California, landlords can't do that. It's called self-help eviction.
Okay.
And it's illegal.
So what kind of things are we talking about?
So things like changing the locks while you're still living there.
Wow, okay.
Or turning off your utilities.
No way.
Or physically removing you or your belongings.
That's wild.
Yeah, and not only is it illegal, but you can use it as a defense if they try to evict you later.
Okay.
And they could even be held liable for damages.
Wow. So tenants should know they don't have to put up with that kind of thing.
Exactly.
Okay, so that's a lot about the eviction process itself. But what about if the property you're renting goes into foreclosure? What happens then? Are there any protections for tenants?
Yes, there are both federal and California laws to protect tenants in foreclosures. The federal law is called the Protecting Tenants at Foreclosure Act, or PTFA.
Okay, PTFA.
And California has its own protections in the California Homeowner Bill of Rights, or HBR.
Right, HBO.
And these laws protect what are called bona fide tenants.
Okay, what's a bona fide tenant?
So it's someone with a real lease that started before the foreclosure.
Right.
They're paying rent that's close to market value. And they're not the former owner or a family member living there without a lease.
Okay.
And bona fide tenants usually get at least a 90-day notice to move out after the foreclosure sale.
Okay, so that gives you some time to find a new place, at least.
Right, exactly.
And what if your lease is longer than 90 days?
In many cases, if you have a lease that goes beyond those 90 days, you can actually stay until the end of your lease.
Okay.
So foreclosure doesn't automatically end your lease early if it has a longer term.
That's good to know.
Yeah, but there is one exception.
Okay, what's that?
If the new owner wants to live in the property themselves, they can end your tenancy with a 90-day notice, even if your lease isn't up yet.
So even then you get 90 days.
Right, exactly.
Okay, so foreclosure is something to be aware of, but it doesn't always mean you're out immediately.
Right. We still have rights.
Okay, so we've covered a lot here, and I know it's a lot to take in.
It is.
And it can be pretty confusing, honestly.
Yeah, definitely.
So what's the most important thing for tenants to remember?
Well, if you're facing eviction or you have any questions about your rights, the best thing to do is talk to a lawyer right away.
Right, a lawyer who knows this stuff.
Exactly, someone who specializes in tenant rights and eviction defense.
Right, and is there anyone in particular that you would recommend?
Well, I know the Martinez Law Center in Santa Ana, California. They have a lot of experience representing tenants in eviction cases.
Okay.
And they work all over Orange County, Riverside, San Diego, and Los Angeles.
Okay, great.
And they focus on helping tenants and renters, not landlords.
Got it. And how can people find out more about them?
Their website is martinezlawcenter.com, and you can find info about your rights and how they can help.
It's okay. martinezlawcenter.com.
Yeah, and a good eviction lawyer can explain your specific situation.
Right.
Help you understand your options, build a strong defense if you're being unlawfully evicted, represent you in court, and maybe even negotiate a solution with your landlord.
Okay, so just to recap, for everyone listening, if you're facing eviction or you're worried about a notice, remember, eviction is a formal legal process. There are rules and timelines your landlord has to follow.
Right.
Make sure you understand why they're trying to evict you.
Yep.
And read that notice carefully. look for any errors.
Absolutely.
Know your rights about the condition of your apartment.
Right.
And remember, you can't be evicted because of discrimination or because you stood up for your rights.
Exactly.
If your building's in foreclosure, you probably have some legal protections.
Right.
A lot of info. But knowing your rights is the best way to protect yourself and your home.
It is. Your home is more than just a place to live. It's your foundation.
Right.
And knowing your rights protects that foundation.
I like that, yeah. And if you're in Orange County, Riverside, San Diego, or Los Angeles, and you need help, check out the Martinez Law Center's website.
Definitely.
MartinezLawCenter.com.
Yeah.
So that's our deep dive for today. I hope this was helpful for everyone and that you understand a little bit more about evictions in California.
I hope so, too.
And especially your rights as a tenant.
Your rights are so important.
Yes. So we'll see you next time.
See you. Bye.
Call now 714-442-9741. Thank you.